The Supreme Court. The Supreme Court is the highest court in the United States. In this video, we will look at the United States court system, how a case gets to the Supreme Court, and what happens once the case gets there. First, let's start with the most basic question. What is the purpose of the Supreme Court? The main job of the Supreme Court is to interpret laws. Since the Supreme Court is the highest court in the United States, it has final say on the interpretation of all the laws. This provides uniformity in interpretation. There are many types of courts in the United States. There are many more than the chart below shows. The purpose of having uniform interpretation of laws is so that in every single one of these courts, federal laws mean the same thing. Laws are applied in a similar manner no matter where a person lives or which federal court their case is in, so he or she is treated fairly. For example, federal laws apply the same way in California as they do in Kentucky, so all people in both states are treated the same. The United States has 91 district courts, which have original jurisdiction over most civil and criminal cases. Original jurisdiction just means that the specific court hears the case first. If a person loses the case, they would want to appeal it. An appellate court doesn't necessarily retry the case. They just look for mistakes and make sure that due process was given. An appellate court is just a panel of judges that serve as the jury. If this case loses in the appellate court, the defendant would appeal to the Supreme Court. Now, the Supreme Court doesn't have to hear the case. The justices on the Supreme Court choose which cases they would like to hear and which ones they don't. If they choose not to hear your case, the decision of the lower court stands. The Supreme Court is also just a panel of judges that act as both judge and jury. The Supreme Court is the only court that is both an original jurisdiction court and an appellate court. It has original jurisdiction in certain areas that are laid out in the Constitution. These are cases involving foreign diplomats, cases between the U.S. and a state, between two or more states, between a state and a citizen of a different state, and between a state and a foreign country. These cases are originally tried in the Supreme Court. For example, if the Ohio River continues to move southward, does this mean that Indiana's borders will change? If so, what does this mean for Kentucky? This type of case would originally be tried in the Supreme Court because it deals with two different states. The Supreme Court is also an appellate court for those cases tried in the U.S. Court of Appeals, the Court of Appeals for the Federal Circuit, and for legislative courts. Cases tried in state courts, however, can still appeal to the Supreme Court. Judicial review is another key purpose of the Supreme Court. Judicial review is the power to determine if a law is constitutional or not. This was established with the Supreme Court case of Marbury v. Madison. But why is judicial review so important? Judicial review is important because it fulfills and enforces the Supremacy Clause. The Supremacy Clause of the Constitution says that the Constitution is the law of the land and nothing can go against it. Judicial review enforces this because it allows the Supreme Court to determine if something does go against the Constitution or not. The second reason that judicial review is so important is that it is the main way that the judicial branch checks the other two branches. Let's take a look at checks and balances. The two arrows that go out of the judicial branch are judicial review of laws and judicial review of presidential acts. The check from the executive branch onto the judicial branch is that the president nominates Supreme Court justices. This ties into the check from the legislative branch because the Senate affirms the presidential nomination. Also, Congress checks the judicial branch by having the power to impeach and convict justices. Yes, Supreme Court justices can be impeached. The process is the same as with the presidential impeachment. Now let's take a look at the organization of the Supreme Court. First, judges on the Supreme Court are not called judges, but they are called justices. This is a sign of respect. There are 9 justices total. There is 1 Chief Justice and 8 Associate Justices. In the past, the number has varied from 5 to 10, but there have been 9 justices since 1869. As we talked about earlier, the President nominates justices and the Senate confirms them. They serve for life and can only leave the court in one of 3 ways. The first way would be if the justice dies. The second way is for the justice to leave the Supreme Court is by resignation. Resignation means that the justice gives up his position on the court. A justice can also leave the court by impeachment, as we discussed earlier. Ideology, otherwise known as judicial philosophy, is what a justice believes and why. There are two main types of philosophy: judicial activism and judicial restraint. Judicial activism is the belief that the Supreme Court should take an active role in using its powers to check the activities of the other branches. Judicial restraint is more controlling in the belief that the court should be limited in what they do. Judicial activism believes in a living constitution, while judicial restraint believes in understanding the original intent of the framers of the Constitution. The atmosphere of the Supreme Court is very different than the other branches. It is very professional and not political. Even though the justices have different beliefs, they treat each other with the utmost respect. It is a different environment than, say, Congress, where conservatives and liberals argue and bicker about topics. Now let's look at the process of a case once it gets to the Supreme Court. Remember, the Supreme Court is both an original jurisdiction court and an appellate court. However, it deals with more appeals than original jurisdictions. The Supreme Court decides which appellate cases to take based on the rule of 4. Each justice looks at the briefs from all the different cases and then decides if they want to take them or not. If 4 of the 9 justices decide to take the case, then the case is tried in the Supreme Court. Now let's go through the process of a case. After deciding which cases to take by the rule of 4, those cases get put on the docket. The docket is just the list of cases that the Supreme Court is going to try in the next term, fall or spring. The briefs for both sides are submitted. Briefs outline the case. They include background on the case, precedent, the legal issues of the case, and the outcome desired. Amicus curiae briefs are also filed. Amicus curiae means friends of the court. These are interest groups who would also be affected by the outcome of the court's decision. Next comes the oral arguments. Each side is given 30 minutes to present their case, no more, no less. The justices can interject with questions at any time during those 30 minutes. The justices have already read through the brief and know the case, so they are just questioning for clarification in order to better make a decision. After both sides have presented their case, the 9 justices conference by themselves, with no assistants or media allowed in the room. They discuss their opinions in order of seniority. The Chief Justice goes first, then the Associate Justices in order of longevity on the court. The justices share their beliefs and then vote on the outcome. Then they decide who will write the opinion. An opinion is the decision of the court. It is what will become law and be used for years to come. The next step is to write the opinion and circulate it for comment. The decision is then announced. There are different types of opinions. Let's look at those now. But first, we need to understand precedent. Precedent is how similar cases have been decided in the past. These cases provide consistency and uniformity. It is very rare to overturn a previous case. The court usually lets the previous decision stand. This is known as stare decisis. The main type of opinion is the majority opinion. This is the official decision of the court and the decision that the president must enforce. This is the law of the land. This opinion is considered an honor to write. If a group of justices need a vote in order to become the majority, they might allow another justice to write the opinion if he or she will vote with them. The next opinion is the concurring opinion. This opinion agrees with the majority, but for a different reason. For example, the majority opinion might believe a law is unconstitutional for violating the Fifth Amendment, while the concurring opinion believes it to be unconstitutional for violating the 14th Amendment. A dissenting opinion is the opposing view of the majority opinion. This opinion lays out legal arguments as to why the majority is wrong. While the dissenting opinion carries no weight in law or enforcement, it can be used someday if the court wants to overturn the precedent set in this case. However, remember that it is rare for precedent to be broken. The opinions shape the interpretation of the law. The decision must be followed and can only be overturned by the Supreme Court. If the people don't like it, they can change the dynamic of the court, liberal or conservative justices, or they can pass an amendment. Lastly, let's take a look at principles of the judicial system. The first principle is equal justice under the law for all. While this hasn't always been followed in the past, think women's rights, slavery, and African American rights, the Supreme Court is constantly striving to improve laws for equal justice. The Supreme Court runs under the adversary system. This means that the best lawyer wins. For example, in the case of O.J. Simpson, many believed and still believe today that he was guilty. However, he hired a group of lawyers known as the Dream Team, and they were able to do their job well enough and convince the Supreme Court that O.J. was innocent. This leads into the next principle, innocent until proven guilty. The last principle is due process. Due process is the right to be treated fairly by law. This is guaranteed by the Fifth Amendment to the Constitution. Remember, the Supreme Court is the highest court in the United States. It acts as both an original jurisdiction court and an appellate court. The main jobs of the Supreme Court are to create uniformity for all laws and judicial review. Judges on the Supreme Court are called justices, and there are 9 total. There are 8 associate justices and 1 chief justice. The justices provide for the judge and jury on the Supreme Court. Criminal cases. Original jurisdiction just means that the specific court hears the case first. If a person loses the case, they would want to appeal it. An appellate court doesn't necessarily retry the case. They just look for mistakes and make sure that due process was given. The Supreme Court. The Supreme Court is the highest court in the United States. In this video, we will look at the United States court system, how a case gets to the Supreme Court, and what happens once the case gets there. First, let's start with the most basic question. So he or she is treated fairly. For example, federal laws apply the same way in California as they do in Kentucky, so all people in both states are treated the same. The United States has 91 district courts, which have original jurisdiction over most civil and criminal. What is the purpose of the Supreme Court? The main job of the Supreme Court is to interpret laws. Since the Supreme Court is the highest court in the United States, it has final say on the interpretation of all the laws. This provides uniformity in interpretation. There are many types of courts in the United States. There are many more than the chart below shows. The purpose of having uniform interpretation of laws is so that in every single one of these courts, federal laws mean the same thing. Laws are applied in a similar manner no matter where a person lives or which federal court their case is.